This discussion, we have really come a long way. So we are looking at post-judgment remedies. But in case you want a discussion group which will continuously keep active in the whole days, then you can look no other than Pass the Bar. We shall be basically answering past papers. So it's better instead of going home and sitting, be part of that group. It's going to give you confidence and basically help you in question approach and give you tips on how fast can you finish in the exam. So having said that, this week the students will be exposed to post-judgment remedies such as revision, review, amendment of judgments, appeals, both High Court and the Court of Appeal. By the end of this module, the students should be able to 1. Explain the principles relating to post-judgment remedies, 2. Present applications for revision, review, and amendment of judgments, 3. Present appeals in the High Court and Court of Appeal, 4. Undertake appellate mediation, 5. Draft the documents relating to post-judgment remedies in civil litigation, and 6. Recognize and deal with ESCO issues. So basically, if you understood appeals in criminal procedure, then these ones are also going to become easier for you because almost they are the same concept, except that they differ in a few instances. So workshop 1, the workshop is on a post-judgment practice arising out of decision of Magistrates Grade 1 and Chief Magistrates. Its first focuses on remedies of review, revision, amendment of judgments, and appeal to the High Court. So basically, a review is always on the same court. A review can arise in the same court. A revision is always the powers exercised by High Court to revise the decisions of subordinate courts. Appeals, we understand appeals is a creature of statute. So it also introduces the students to interlocutory remedies available to aggrieved party in order to preserve the identified post-judgment remedy. So basically here in civil litigation, we shall be looking at stay of execution as a post-judgment remedy. So learning outcomes, explain the various principles regarding revision, review, and amendment of judgments and appeals to the High Court. Present applications for revision, review, and amendment of judgments and appeals to the High Court. So basically, we shall look at revision. Revision is exercised by High Court. Review by the same court. Amendment of judgments. Basically, we shall look at how do you, for example, issue or maybe how do you ask for additional evidence to be admitted on appeals. Present application to revision. Present an application for stay of execution pending the post-judgment remedies. Draft the documents relating to post-judgment remedies, and recognize and deal with ESCO issues relating to post-judgment remedies. So here among the amendment of judgments, we shall look at the SRIP rule. Amendment of judgments or the SRIP rule arises where there is an error on the judgment. For example, instead of writing 1 million, someone wrote 100,000. Then you can proceed under the SRIP rule, or what they have called amendment of judgments, and then you can have the judgment amended. Draft the necessary documents which shall be notes of appeal and grounds and memorandum of appeal. Present an application for stay of execution and also ESCO issues. So part A, assume that this morning at your office, MS Bath and Company Advocates, a gentleman, Modiobari Peter, has come to you and narrated the following. That is the resident of Senior Quarters, Central Division Mbari, and a registered proprietor of land at Mbari. He inherited this land from his late father, that he has been having a protracted dispute with his neighbor who has continuously been trespassing on a portion of his land, claiming to be his chibanja. He always plants seasonal crops like maize and beans, which he has been destroying, but the neighbor is notorious and has refused to stop the habit. In 2021, he filed civil suit number against Nambosi for trespass claim for an eviction order and damages, or they filed a counterclaim in which he claimed to be the rightful owner of the chibanja on the land which he bought from Editor in 2016 and has been growing crops thereon. The matter was heard inter partes, and the Chief Magistrate, Her Worship Josephine, delivered judgment on the 4th of August 2025 with the following end orders. The plaintiff suit is dismissed. Judgment is entered in favor of the defendant. The defendant is declared the right owner of the land. The title of the plaintiff is cancelled. and the defendant is awarded the general damages of Uganda shillings 53 million, and the defendant is entitled to costs of the counterclaim. Task 1 advised Peter Mudihobore on the quickest and most appropriate remedy. The most appropriate remedy available to him in the circumstances. So basically, how we would go for revision, you can see that the magistrate court awarded the general damages of 53 million, and basically he doesn't have power to award them. So basically, how we would go for revision in the High Court. The procedure to be followed to obtain the remedy and necessary documents would be notice of motion and affidavit in support for revision. Part B, assume using facts in Part A the matter proceeding as a trespass to land where Peter Mudihobore has been living with his wife and children. He inherited the said Chibanja from his late father. The Chief Magistrate had proceeded on the presumption that the parties were Bibanja holders and gave the following orders. Plaintiff's suit is dismissed with costs. Judgment in favor of the defendant. The defendant is rightful owner of the Chibanja. Defendant is awarded the Uganda shillings 7 million as general damages, and defendant is awarded the cost of the suit. When Peter came to your efforts, he informed you that actually he has discovered that his registered proprietor of the land complies in LLV. He even has a land title to that effect, which has a mortgage with the FCU. Informed you that he recently discovered this from his late dad's friend who migrated from his home area to Bundubujo. He recently met him at Kwanjura ceremony in Kampala for his niece, Sitalo Susan. His late father had mortgaged the same with the bank, and there is an outstanding balance of 7.2 million. Advise Peter Mudihobore on the remedies available to him. So basically, here we can appeal, whether he has a right of appeal, and basically whether he can adduce additional evidence on appeal, draft the necessary documents, which shall draft the notice of appeal together with the memorandum of appeal, and then documents for additional evidence, which is a notice of motion and affidavit in support. Part C, Fang Cheng is the director of Bere Investments Limited, has come to you chambers and handed you a copy of judgment here to attach as an Annexure A. Informs you that is unhappy with the orders therein, and there is no way the company can pay such money to the defendant who on her own abandoned work and caused financial loss to this company. He also informs you that recently an auctioneer by the names of Muzirana Ben called him, telling him that he has court papers to serve him in respect of the payment of the decretal sum. He gave you a copy of notice to show cause here to attached and marked B. When you checked on the court record, you found that the judgment creditor has applied for attachment and sale of 3 of the company vehicles used to deliver merchandise to the company's customers. Cheng further informs you that he had traveled to China and returned on the 9th of September to find the above state of affairs. Advised Cheng on the remedies available to the company's circumstances, the procedure to be followed, and draft the necessary documents. So basically, here we are looking at stay of execution. Where you have to first lodge an appeal, but stay of execution is always by notice of motion and an affidavit in support. So basically, we shall be looking at that. Part A, we have a revision. Part B, we are looking also at. Remember, this workshop we are supposed to discuss, review, revision, appeals, and stay of what? Stay of execution, as well as sleep rule, or what we call amendment of judgments. So let's proceed to workshop 2 briefly. The workshop is on post-judgment remedies after decision of the High Court. It focuses on appeals from decision of the High Court to the Court of Appeal, together with appeals from apparent decrees from the High Court to the Court of Appeal. It also addresses aspects of the sleep rule and references. It also spans to interlocutory remedies, including to preserve the right of appeal or revision. So by the end of this workshop, the students should be able to explain the various principles regarding appeals from the decision of the High Court, the Court of Appeal, together with appeals from apparent decrees from the High Court, the Court of Appeal, peruse the record of proceedings and judgment of the High Court and formulate the grounds of appeal, prepare a record of appeal and present it to court, take all preliminary steps and interrogatory proceedings prior to the hearing of an appeal for both the appellant and the respondent parties, and draft all relevant documents necessary to prefer, prosecute, and oppose an appeal from the High Court, the Court of Appeal, together with appeals from appellant's decrees from the High Court, the Court of Appeal, and organize and deal with ESCO issues. So part A, we have Moses Kasim, Management Director of MS Chip Head Hardware, came to your chambers on Kabaka Njagala Road in Kampala. He tells you that company is dissatisfied with the judgment of Honorable Justice Jom Okero. He has given you a copy of proceedings and judgment there to attached and annexure C and D. Advise Moses Kimi on the remedies available for Chip Hardware Limited, the procedure to be followed to obtain the said remedies, the grounds for the remedies, and reference documents. So basically the remedies here, when you look at the judgment, most likely this is going to be an appeal procedure. You have to lodge a notice of appeal, memorandum of appeal, then grounds. We have to look grounds for appeal, like the way we did in criminal, and draft a notice of appeal as well as the memorandum of appeal. Then part B, assume that a week after you obtained your instructions, Kasim returns to your chambers and informs you that he was served with documents collectively annexed as annexure E, and informs you that actually the plaintiff wants to attach his bank account and his residential house where he lives with his family. On perusal of the court file, you have discovered that the register issued a warrant of attachment for a residential house comprised in block 20. Task 2, advise Kasim on the remedy available to him in the circumstances, draft the necessary documents in A above. So basically here you can see they want to attach a family house. So basically here we have to stay of execution and staying execution and appealing the judgment. But basically I shall be looking at stay of execution. Stay of execution, I think, by notice of motion and affidavit in support. Then part C, assume further that you are a lawyer for the plaintiff, and part A informs you that during the hearing he was not able to produce an invoice for the supply of construction materials that was disputed by the plaintiff as a result of the shifting their offices from the city center to Ntinda suburb. Some documents were misplaced. However, he was recently able to trace and obtain a delivery note here to attach and marked as an extra if you have also recently served with a notice of appeal, a letter requesting for proceedings, and a memorandum of appeal that said matter. Remedies, basically how we're looking at how do you adduce additional evidence on appeal, where we shall look at the documents, the notice of motion and affidavit in support. So basically that is it for part C. Part C, we are basically looking at appeals from the High Court, the Court of Appeal. We are dealing with interrogatory proceedings, for example, stay of execution. We are dealing with how do I adduce additional evidence on appeal. Remember, I have to get leave from court. Then workshop 3. This workshop is on post-judgment remedies after decision of the High Court. It focuses on appeals from the High Court, the Court of Appeal. The facts under workshop 2 part A will be used. By the end of the workshop, students should be able to 1. Explain the various principles regarding appeals from the decision of the High Court, produce a record of proceedings, prepare a record of appeal, draft all relevant documents, and organize and deal with ESCO issues. So basically that was it, and we have the annexures. I think thank you for listening to this discussion, but I will always have a detailed discussion which basically helps you understand the gist of the workshop. We apply the law and you are better equipped for the IA. So in case you want a discussion group which will be discussing all the past papers, please, you can be part of the Pass the Bar in the whole day. So if you have never been part of the Pass the Bar, you can be part of the group in the whole day as we prepare you to leave the center. So please remain the Pass the Bar team. We wish you success in your IAs. The purpose of this YouTube video was to ensure that you understand what we shall be covering last week, but in case you want a detailed discussion, then you can join us on our weekend discussions. Please have a blessed weekend.